Hillman and Joe Ferlita speak to us today. The topic is, can a New York settlor create a silent trust? So I think it's obvious that you want everybody to be on mute, right, during that. Okay, given the topic more than anything else. So I do want to just say a couple things. I typically grab a couple thoughts out of resumes and CDs. I do notice Jennifer's is a lot longer than Joe's, but I don't know exactly why, Joe. But well, she's got a lot more articles, but Jennifer, unbelievable with her background and everything that she's been doing, is an immediate past president now for the New York State T&E law section, right? The only thing, Jen, I don't see here is that you're a member of our organization. So we're going to work on that.
Can I just say my application was submitted to someone?
All right, we're going to work on that. But anyway, all right. So Joe, Jen, it's all yours. Both partners in Rivkin Radler being one of our platinum sponsors. Very, very happy they're here with us today, and I know you're going to enjoy this presentation. So thank you.
Good morning, and thank you to my partner, Jennifer Hillman, for selling me down the river.
That's what I do.
So we're talking today about quiet trusts. And the first issue I want to discuss is, what is a quiet trust? Because although this concept has been around, I find that a lot of people aren't familiar with them, and including trust and estates practitioners, let alone clients. So what is a quiet trust? Quiet trust is really it's really a colloquial term. And all it does is refer to a trust that's typically irrevocable, that by its terms limits, or purports to limit the trustee's disclosure of information about the trust, including, in some cases, the very existence of the trust. It's not that these quiet trusts don't have beneficiaries. They do. The trust typically lists the names of the beneficiaries or describes them by a class. But when you have a quiet trust, it's simply that the trustee can't tell the beneficiary certain things about the trust. So why are we bringing this topic to you? Why? What's the point? Why do we care about quiet trusts? Well, number one, they are gaining in popularity, and over the last few years, I have had more than one client, a few clients, ask me about them, demand that I draft them. But if you really wanted to get a little more philosophical, why do we care? We care because we all work for clients who want their cake and eat it too. So what do I mean? The clients want it all. And why not? They're the client. They want a trust, to create a trust that benefits or provides for their family and offers all of the benefits that a trust gives: tax savings, protection of assets from divorce, from creditors, providing a safety net for their children when they're gone. But some clients are afraid of raising trust fund babies. Stated differently, they're concerned that their children's knowledge of a large trust for their benefit will lull those kids into a non-productive life, a life where they do not develop the virtue of a strong work ethic. So the clients are concerned, some clients, not all, some clients are concerned that their children will become, self-indulgent and focus on consumption and all of the negative consequences that go along with it. While the notion of a quiet trust, again, has been brewing for, I'm sorry? Did someone say something? Okay. While the notion of a quiet trust has been brewing for decades, they really catapulted into the spotlight about 10 years ago. Remember, 2012, what was going on in 2012? Well, a lot of you will remember that was when the $5 million gift and estate exemption was scheduled to be reduced to $1 million. And those of you old enough, and I think we're all pretty much old enough, who were practicing at that time, you remember what the last quarter of calendar year 2012 was like. It was extremely busy. Everyone and his brother was creating a trust, a slat, and it was very similar to what happened at the end of 2020, more recently, just after the election. Everyone was in a frenzy to make lifetime gifts to use their exemption before they thought they would lose it. So the result was this sort of artificial incentive to create these irrevocable trusts funded with millions and millions of dollars. And really, when you think about it, that artificial incentive was really a tax motive. These trusts were created for tax reasons, as opposed to all the other reasons that people might ordinarily create a trust. Now, we, of course, in the Nassau County Estate Planning Council know that good estate planning should not result in the tax tail wagging the dog. The fact is that it often does. Some grantors were, in fact, painfully cognizant of this fact. They were worried about it. And so they tried to mitigate the situation with a quiet trust. Let's just create the trust, get it funded, but not tell our 15-year-old that he's got a trust, for his benefit with $10 million in it. So what's the problem? What's the problem with doing that? Why not just prohibit the trustee from telling the beneficiary about the trust or from giving the beneficiary information about the trust? Well, the problem is that these prohibitions on the trustee might not be legally enforceable depending on the jurisdiction you're in. Or even if they are enforceable, they might put the trustee in a tough position where the prudent path is not so clear. In short, quiet trusts could cause a collision between a trustee's duty to carry out the terms of a trust and the trustee's basic duties as a fiduciary, which includes transparency and disclosure. Now, in order to really appreciate this, let's just think about some basics about what is a trust. A trust at root is a relationship. It's not a distinct entity like a corporation or an LLC. It is a relationship between the trustee, who's the fiduciary, and the beneficiaries of the trust. And it's a relationship that is forged by the grantor, the creator of a trust. Now, just think of it in simple terms. Many of us own a home, okay, in which we live. We have title to the house. What do I mean by that? We have legal title and beneficial title. Now, legal title, our name is on the deed, okay? We can decide when to sell the house, if we want to place a mortgage on it, etc. All of those things. We also have beneficial title. What does that mean? We get to live in the house, enjoy it, okay? So there's no separation in the case of our own ownership of a home between legal title and beneficial title. But with a trust, there is a separation. The trustee has legal title and the beneficiary has beneficial title, beneficial ownership. That separation gives rise to a natural tension between the trustee and the beneficiary. That tension either results in a beneficiary being happy and accepting the trustee's acts, or, my friend Jennifer, it results in an unhappy beneficiary convinced that the trustee's acts were improper. But a beneficiary cannot approve or disapprove things that he's not aware of. In short, disclosure of information is the common denominator here. That's why over the centuries, trustees have been charged with the duty to answer questions about the trust when posed by the beneficiaries. Generally, the trustee has a duty to disclose trust information when requested by a beneficiary. Many say that this duty to disclose is what keeps trustees honest and ensures that the beneficiary's interests will be served. Now, quiet trust in some ways removes this common denominator of disclosure. Some would question whether a quiet trust really is a trust at all. How can it function? So, Jennifer, bringing this to a more granular level, how does this trustee's duty of disclosure play out in the litigation context, particularly accountings?
Thanks, Joe. So, Joe talked to us a little bit about what it means to be a fiduciary and that long recognized duty to inform the beneficiaries in certain situations, and focus on that trustee's duty to timely and appropriately respond to a beneficiary's inquiry, and that includes inquiry into the trust terms, its assets, and what the trustee's been doing. So the idea, again, as Joe said, is to keep trustees honest. You want to keep them honest. So the beneficiaries are given the tools to police the trustee so that the trustee doesn't neglect their fiduciary duties. So we have this fiduciary duty to keep certain classes of beneficiaries reasonably informed. But what does that really mean practically? Okay, so generally it's thought to include providing notice of the existence of the trust, that it even exists, and informing the beneficiaries of their right to request information. Now, Surrogates Court Procedure Act 2205, it provides a very extensive list of individuals and entities, including income and remainder beneficiaries, that have standing to petition the court to compel judicial settlement of a trustee's account. So if a trustee is not voluntarily providing information to satisfactory disclosure to the beneficiaries, there is an extensive list of individuals who could come forward and petition the court to compel an accounting and, in a way, demand that disclosure. But let's look at it from the other way. As a fiduciary, why do you account? Why do you account? Because, of course, you want to comply with your fiduciary obligations, which include that duty to inform. You want to be certain that you're satisfying that punctilio of honor that Judge Cardozo spoke about so many years ago. But also from a much more practical standpoint and a more selfish standpoint, the trustee accounts and provides information to beneficiaries because they want to be released, they want to be paid, and they want to start the statute of limitations. So a release from a beneficiary, it's only as good as the information that's provided. If the trustee wants to be released from liability, or they want to have that, be able to sleep at night knowing that they're not going to have a beneficiary coming after them, 10 years down the line, they need to provide some form of an accounting, some form of information to the beneficiary. If the information that they provide to the beneficiary is limited, the beneficiary may be later able to set aside that release on the basis of fraud, misrepresentation, whatever the case may be. So that disclosure, or even an informal accounting, may start the statute of limitations on any claims that a beneficiary could have against a trustee, provided the act is actually disclosed. Okay, so again, that goes back to what information have you actually told people? I can't be deemed to have knowledge of something, as Joe mentioned before, that I don't know about. So the CPLR sets forth statute of limitations, which is essentially timeframes within which people need to come forward and make their claim, in which a person must present their claim and file a case. But, I lost my spot. But the statute of limitations on many claims that deal with an accounting and deal with the trustee, they may not even start to run until the accounting is filed, or until the trustee discloses the act to the beneficiary. So even if you have a contract claim that's really only a 6-year, statute of limitations, and they say, well, it happened, 10 years ago, if it wasn't disclosed, that might not have started the statute of limitation. So the value of the accounting is that it protects the trustee. But a fiduciary also wants to get paid, okay? So a trustee, it's a job. It's a job, and it's probably a very thankless job. So they're entitled to be paid for it. In order to obtain annual commissions, a trustee has to provide annual statements to income beneficiaries or beneficiaries with an interest in the principal of the trust if they request it. So, and that's, that's statutory, that's the law. And if you fail to provide annual statements, distribute out all of the income, and fail to retain your commissions, a trustee may have to forfeit a third of their annual commissions that they're entitled to. So, there again, you want to get paid, you got to provide information. And even a trustee who's not required to furnish annual statements because they haven't retained annual commissions or whatever the case may be, they're still required to furnish those annual statements to any beneficiary receiving income or any person interested in the principal of the trust who requests them. So again, you request it, you got to give it. So between getting paid and being protected, there's clearly an incentive for the trustee to provide information. But notwithstanding the incentives, there are some things that a grantor can incorporate into the trust terms and some limitations on disclosure. We have had cases where we've been able to kind of look at the limits of what a grantor can do when they're creating a trust. So first of all, these rules, they don't apply to a revocable trust, okay? A revocable trust, it's ambulatory. It's kind of like a will. You don't really need to disclose it during your lifetime. The grantor, can change it. They can revoke it at any time. So there's limitations on there. There's really no need for there to be extensive disclosure with respect to a revocable trust. But it has been held in recent case law that even the grantor of an inter vivos irrevocable trust may relieve the trustee from accounting to the remainder beneficiaries during the grantor's lifetime, provided the trust explicitly states that. So there you have it. There's a case where you can say in the trust, trustee, you don't have to provide an accounting to the remainder beneficiaries during the grantor's lifetime. There's also cases where the court held a valid provision in an inter vivos trust instrument, which limited the rights of beneficiaries to even compel an accounting and required that the trustee be held accountable only to the grantor. That was crazy to me, because now you literally have a situation where the only person that the trustee is held accountable to is the grantor. But again, each of these limitations is linked to the fact that the grantor is still alive. So a grantor cannot attempt to completely excuse the obligation of a trustee to account to anyone. That's just simply void against public policy. That's the public policy of New York State. But turning to the other side of the beneficiaries, what's interesting is, as a beneficiary, you can also turn off the flow of information. Why you would want to, I'm not entirely sure, but it is the law, and there is a statute that says that a beneficiary, a current income beneficiary, can waive receipt of annual statements if they do so in writing. And this excuses the trustee from furnishing annual statements while still retaining their commission, so they're still getting paid, but until the beneficiary asks for the annual statements to be started to be disclosed to them again. But I think the point here is that overall, New York law, it's not particularly friendly to individuals who want to create these quiet trusts.
Thank you, Jennifer. Indeed, New York is generally not friendly to quiet trusts. Other states are. Other states are quiet trust friendly. Not all of them, but many are. This is just one example, by the way, of New York being behind the times in the development of trust law. Other states have modernized their laws where New York has resisted, notwithstanding the fight that many in New York, including Jen and me through our work in the Bar Association and many others, have put up. Now, this has caused, this is a little bit of a practical footnote here. This has caused many grantors, including some of my own clients, to create trusts in other states. It's not a surprise that Peter, when he was giving his little, giving us his information, told us that he's chartered in Delaware. He's quick to mention that, because clients have good reason to leave New York to create a trust. New Yorkers, I'm talking about. Forget about people leaving the state, entirely. So this has an economic impact on New York in the form of lost taxes and jobs. And studies have demonstrated this over the years. One of the most well-known studies on this is a study called the Appleseed study, and it's getting old now. It's from 2005, but it shows how New York's economy loses hundreds of millions of dollars a year and many, many, many jobs from lost revenue that is generated by trust activity, trusts that would have been created in New York, but they were created elsewhere because of our outdated trust laws. Conversely, other states have benefited from New York's, whatever you want to call it. There's another study, I think it's in the materials,